Why do the Pandora Papers matter? These are 11.9 million leaked files from 14 global corporate services firms which set up about 29,000 of the self companies and private trusts in just obscure tax jurisdictions, but also countries such as Singapore, New Zealand, and the United States for clients across the world. There are at least 380 persons of Indian nationality in the Pandora Papers. Of these, the Indian Express has so far verified and corroborated documents related to about 60 prominent individuals and companies. What do the Pandora Papers say about these entities? Also, if trusts are not illegal, what is the investigation about? What are the Pandora Papers? These are 11.9 million leaked files from 14 global corporate services firms which set up about 29,000 of the self companies and private trusts in not just obscure tax jurisdictions but also countries such as Singapore, New Zealand, and the United States for clients across the world. These documents relate to the ultimate ownership of assets settled or placed in private offshore trusts and the investments including cash, shareholding, and real estate properties held by the offshore entities. There are at least 380 persons of Indian nationality in the Pandora Papers. Of these, the Indian Express has so far verified and corroborated documents related to about 60 prominent individuals and companies. This is an ongoing investigation. What do the Pandora Papers reveal? The Pandora Papers reveal how the rich, the famous, and the notorious, many of whom were already on the radar of investigative agencies, set up complex multi-layered trust structures for estate planning in jurisdictions which are loosely regulated for tax purposes but characterized by airtight secrecy laws. The purposes for which trusts are set up are many, and some genuine too. But a scrutiny of the papers also show how the objective of many is twofold: to hide the real identities and distance themselves from the offshore entities so that it becomes near impossible for the tax authorities to reach them. Second, to safeguard investments, cash, shareholdings, real estate, art, aircraft, and yachts from creditors and law enforcers. How is Pandora different from Panama Papers and Paradise Papers? The Panama and Paradise Papers dealt largely with offshore entities set up by individuals and corporates respectively. The Pandora Papers investigation shows how business have created a new normal after countries have been forced to tighten the screws on such offshore entities, with rising concerns of money laundering, terrorism, funding, and tax evasion. The Pandora Papers pierce the corporate veil and reveal how trusts are prolifically used as a vehicle in conjunction with offshore companies set up for the sole purpose of holding investments and other assets by business families and ultra rich individuals. The trusts can be set up is known tax havens such as Samoa, Bilge, Panama, and the British Virgin Islands, or in Singapore or New Zealand, which offer relative tax advantage, or even South Dakota in the US, the biggest economy. What is a trust? A trust can be described as a fiduciary arrangement where a third party referred to the trustee holds assets on behalf of individuals or organizations that are to benefit from it. It is generally used for estate planning purposes and succession planning. It helps large business families to consolidate their assets, financial investments, shareholding, and real estate property. A trust comprises three key parties: settler, one who sets up, creates, or authors a trust; trustee, one who holds the assets for the benefit of a set of people named by the settler; and beneficiaries, to whom the benefits of these assets are bequeathed. A trust is not a separate legal entity, but its legal nature comes from the trustee. At times, the settler appoints a protector who has the power to supervise the trustee and even remove the trustee and appoint a new one. Is setting up a trust in India or one offshore outside the country illegal? No. The Indian Trusts Act 1882 gives legal basis to the concept of trusts. While Indian laws do not see trust as a legal person entity, they do recognize the trust as an obligation of the trustee to manage and use the assets settled in the trust for the benefit of beneficiaries. India also recognizes offshore trust set up in other tax jurisdictions. If it's legal, what's the investigation about? This is a very valid question. True, there are legitimate reasons for setting up trusts, and many set them up for genuine estate planning. A business person can set conditions for beneficiaries to draw income being distributed by the trustees or inherit assets after his or her demise. For instance, while allotting shares in the company to say four siblings, the father, the promoter set conditions that a sibling can get the dividend from the shares and claim ownership of the shares but not sell it without offering the first right of refusal to the other three siblings. This could be to ensure ownership of the enterprise within the family. But trusts are also used by some as secret vehicles to park ill gotten money, hide incomes to evade taxes, protect wealth from law enforcers, insulate it from creditors to whom huge monies are due, and as time to use it for criminal activities. The Indian Express investigation reveals this. So, why are trusts set up and why overseas? What should you also know? Overseas trusts offer remarkably secrecy because of stringent privacy laws in the jurisdiction they operate. A lot depends on the intention behind setting up an offshore trust, and if the taxman can provide evidence that suggests malafide intent by the trust, then the courts tend to back the tax department in their attempt to recover the taxes due. From the investigation, some key tactic reasons why people set up trusts are: maintain a degree of separation. Business persons set up private offshore trust to project a degree of separation from their personal assets. A settler of a trust no longer owns the assets he places or settles in the trust. This way, he insulates these assets from the creditors. This is the best illustrated through an example. A real estate promoter sets up an offshore trust which sits on top of four offshore entities holding some assets. Now, private equity investors drag various entities on of the real estate group to the National Company Law Tribunal under the bankruptcy law. So do home buyers who have invested in residential properties by the company. But the Pandora Papers show the promoter moved tens of millions of dollars in assets to the trust amid police complaints in Delhi by his foreign investors alleging siphoning off funds to the tune of hundreds plus millions dollars. His wealth moved to an offshore trust remains safe from creditors. Hunt for enhanced secrecy. Offshore trusts offer enhanced secrecy to business persons given their complex structure. The income tax department in India can get to the ultimate beneficial owners only by requesting information with the Financial Investigation Agency or International Tax Authority in offshore jurisdiction. The exchange of information can take months. Avoid tax in the guise of planning. Business persons avoid the NRI children being taxed on income from their assets by transferring all the assets to a trust. The ownership of the assets rests within the trust, and the son, daughter being only a beneficiary is not liable to any tax on income from the trust. In many business families, children have one foot abroad, hence, family patriarchs have increasingly looked at trust to ensure a hassle free transfer of assets into their children's hand. 4. Prepare for estate duty eventuality. There is a pervasive fear that estate duty, which was abolished back in 1985 when Rajiv Gandhi was Prime Minister, will likely be reintroduced soon. Setting up trusts in advance, business families have been advised, will protect the next generation from paying the death inheritance tax, which was as high as 85% in the more than 3 decades after its enactment. The Estate Duty Act 1953. Although India does not have a wealth tax now, most developed countries, including the US, UK, France, Canada, and Japan, have such an inheritance tax. Flexibility. In a capital controlled economy, India is a capital controlled economy. Individuals can invest only $250,000 a year under the Reserve Bank of India's liberalized remittance scheme LRS. To get over this, business persons have turned NRIs, and under FEMA, NRIs can remit $1 million a year in addition to their current annual income outside India. Further, the tax rates in overseas jurisdictions are much lower than the 30% personal IT rate in India's plus surcharges, including those of the super rich, those with annual income over rupees 1 crore. The NRI's angle, offshore trust as noted earlier, are recognized under Indian laws, but legally it is the trustees, not the settler or the beneficiaries, who are the owners of the properties and income of the trust. An NRI trustee or offshore trustee taking instructions from another overseas protector ensures they are taxed in India only on their total income from India. Of late, NRIs are under greater scrutiny of the income tax department. They have been receiving notices to prove their non-resident status of past years, to check if they made the required disclosure of foreign assets in years when they were ordinarily resident in India. Can offshore trust be seen as resident Indian for tax purposes? There are certain gray areas of taxation where the income tax department is in contestation with the offshore trust. After the black money, undisclosed foreign income and assets and imposition of tax 2015 came into existence, resident Indians, if they are settlers, trustees, or beneficiaries, have to report their foreign financial interests and assets. NRIs are not required to do so. Even though, as mentioned above, the IT department has been sending notices to NRIs in certain cases. The IT department may consider an offshore trust to be a resident of India for taxation purposes if the trustee is an Indian resident. In cases where the trustee is an offshore entity or an NRI, if the tax department establishes the trustee is taking instruction from a resident Indian, they too the trust may be considered a resident of India for taxation purpose. For instance, if one case the Indian wealth manager has been appointed a protector with powers to supervise the trustee by an offshore trust, leaving a window open for the taxman. Thank you.